Hello and welcome back to the channel and another of my interview series. Now you may remember a few days ago had the amazing Stan McDonald on. We were doing a sort of an introduction to the law, what was lawful, what was legal, using the acts and statutes and understanding them. But we were looking a little bit about council tax, and we were talking about that sort of thing by popular demand, ladies and gentlemen. I can tell you, lots of emails, lots of comments. Stan is back and he's put together a presentation that we're going to sort of walk through. Now I may ask some very stupid and ignorant questions, and hopefully Stan will be able to tolerate that and answer those with me. So we're looking at legal maxims today. Now, we will cut to Stan halfway through or in the middle of his presentation slides. There he is. Hello, Stan.
Hello, Richard.
Nice to see you there. I've got a tiny little image of you because we're sharing the screen, and I record slightly differently than the normal Zoom way. I may have to investigate how Zoom way does it. So, but for now, sticking with the system that I know, how are you doing, Stan? You all right?
I'm doing pretty good. And as you mentioned earlier, we were talking about an introduction to law, and we sort of covered on the council tax. And I have a presentation that's prepared for that, so we can address that at some point in the future. But today, we're talking about legal maxims.
Legal maxims, right? What exactly? And before we get into, you're probably going to tell us what they are, but just in a nutshell, what does that mean?
Well, a legal maxim goes back to roughly the 1400s, and basically, it's something that's been argued over time. And it's now become, we're not going to argue it anymore. It's basically a fact in law.
Right.
The problem is that there's thousands of legal maxims. So where does one begin? How does one find them? This is the problem. If you don't know of the legal maxim, you may have a perfectly great argument if you only knew. And if you don't know about it, then you're kind of up the creek. Yes. Now, if you happen to have Black's Law Dictionary, 11th edition, it has all kinds of legal maxims in there, but by no stretch of the imagination is it a complete list. I mean, there's thousands of them. And the thing is, what I tried to do here is I got 30 maxims that will deal with, or approximately 30, that deal with most legal arguments. And those legal arguments can be presented in either in an argument or in an affidavit. And we can, at some point, go through and go over affidavits and legal procedures and how to file paperwork. But for those that are not familiar, this is Black's Law.
Oh, yeah. I did buy a copy of that.
Right.
It's not cheap.
No, what the best way to find these books are, if you guys want the ISBN, you can look it up that way, too.
Oh, yeah.
If you want to find books, that one of the easy ways to do it is go on Google, on eBay, and you can often find somebody selling a used copy of the book. But as you alluded to the other day, Black's Law has been revised. I think they're on the 12th or 13th edition. And what you really want to do is find the older editions, because the older editions will have certain things in it, and the newer editions will have other statements in there. And it doesn't matter where you get your legal reference from when you make your legal document, as long as you tell them where exactly it came from.
Oh, I see. Yes. So you're telling them the dictionary that that's your reference point, so everybody knows, rather than, because I noticed in the Black's Law Dictionary that I've got, that one that you just showed, some of the terms that have been identified in the past seem to be less stringent, I suppose, or the legalese seems to be ironed out more into what we would have in, say, the Oxford English Dictionary.
Right, and that's one thing. If your viewers want it, I will make up a presentation similar to this one, and we can go through some of the legal words. Obviously, the thickness of the dictionary, you can't go through them all, but what people can do is they can actually look on Google and just Google the word Black's Law 4th edition or Black's Law 4th, and there is a PDF file circulating out there.
Ah, right. Oh, okay. Thank you for that. Yeah, that's good.
Yeah, and I don't know. I mean, somebody might say it's copyright infringement, but If you're not selling it, you're only making reference to it, then how
Yeah.
can they go after you? Right?
Brilliant.
If you want that PDF file, I'm pretty sure I can locate it and fire it off to you. That's no problem.
You'll-
Because the
we'll
thing
put-
is, the people, if they don't know what to look for, that's the problem.
Yes, absolutely. Well, I think what I'll end up doing is putting a reference page on my website, richardvobes.com, with all these PDFs so that people can access them easily.
Yeah, it looks like I'll have a lot of things to send you.
Right, shall we get into the legal maxims then? I'm going to move your little screen that I've got there off out the way, and I can see you, but the audience can't, and they can't even see me, so that's a bonus. And we have your title screen here, Legal Maxims.
Yeah. And on the Legal Maxims cover sheet or cover screen here, you will find the source for the PDF file. But as Richard said, he already has the file. I converted it to a PDF for him, and I sent it over, so it'll be on his reference page whenever he gets around to uploading it.
Yeah, it'll be certainly there by beginning of next week. I'll send it to my chaps that look after the website.
Oh, that's not your job, is it?
It's not my job. Luckily, I have some volunteers, so they've very kindly set up the website. They've got their own Black Cat Somerset computers, so give them a plug. Or Black Cat Computers in Somerset, just for the reference.
Mm-hmm.
Anyway, right, yes, over to you, sir.
Okay, I have to minimize my own screen here just to have a sec. Put me up in the corner. Okay. Legal maxims. As Richard said, the legal maxims, and as I alluded to earlier, legal maxims come from the 14th century and then after that, and basically go back to like really, really old law. If you remember from my first presentation, I said that the older the law, the better it is. And this is going to be expressed today. Before I do this, I don't want to get Richard in any problems. So legal disclaimer, Richard or myself are not responsible for how you use this information, and it is your job to verify it's current and up to date. We will do everything we can to try and direct you to the right resource or the right information, but at the end of the day, it's your responsibility on how you use or misuse this information.
Right, thank you very much for that.
Yeah. What is a legal maxim? A legal maxim is an established principle of law or an argument, and basically most of our law system is run under Latin terms or Latin language, and then it's transposed, and that's just the way it is. It's similar when you deal with medical stuff, but what we're going to do is break it down so it makes sense, because if most people don't talk Latin, so we got a problem. But the principle is a collection of arguments basically in English law. In English law, that would apply. Some people have a question like, can I use a legal maxim even though I get it from a US reference or I get it from a UK reference? And the actual answer is yes, because it's old law, and Canada and Australia and UK and US, we're all operating under the same bar association, or they're under the realm of the crown. Right. We'll get into that more later. But the thing is, yes, you could use it. And the same thing if you reference a case, if you reference an old precedent case, if it's from a higher court and it's in your country, the courts are obligated to follow it. If it's from a different court, like let's say United States or Canada, it's to sway the court. It's not necessarily they're going to listen to it. But if you give 2 or 3 references that say the same thing, that's the general term. I mean, I can write up an affidavit. In fact, I did. It's 478 pages. And I can quote 35 or 40 statutes. But there's got to be a limit, eh? And same with legal maxims. But these legal maxims can be extracted from the PDF file that Richard has, and he'll have uploaded, and it can be copied in an argument. And as long as you can articulate what that is, because as we said in our last presentation, it's up to you to present your evidence both orally and written. And I suggest doing both, because if a person gets into an argument with the court and the court doesn't want to listen, their job's to render a verdict based on both, so they have no excuse.
Right. Okay. Brilliant.
Yeah. The legal maxim sheet that's a PDF file looks like this. And it goes through, there's all kinds of listing, but we're going to go through each one. And it talks to you about the legal maxim. Then it gives the literal meaning, the interpretation, And then it references in the fourth column, it actually gives you a court case. So if you're referencing a legal maxim, you can now reference the court case that supports to it. And then it actually tells you what paragraph within that court case. So
wow.
you have no argument, no reason not to be able to use some of this. Now you're looking at it going, oh, great, what the heck does all this mean? And that's the purpose of this presentation.
Yeah. Yeah. So the fact that it's been used in a court case means it's been tried and it's been accepted.
Exactly.
Yeah.
Exactly. Now, if you reference a legal maxim, don't go in there and say, well, this is funny language, I'm going to change it. Don't do that.
No.
But there's about 35 points. Now, court actions could be heavy. This is important. And this is where, like, a lot of people are getting shafted in the court. They're getting, the short end of the stick. But according to this legal maxim, if you have any undeserved or unfair advantage that's been gained by the other party, okay, invoking the jurisdiction of the court because they're using the court as a tool to get their verdict, okay, if they do it unlawfully or illegally, the court has a legal obligation to neutralize it or cancel it. In other words, no man should suffer because of the fault of the court. So if the court screws up, you have a remedy against the people in the court. You can't go after a corporation. Well, I mean, you can, but, I'll ask you a question, Richard. How many cars did General Motors make last year?
No idea. Loads.
None.
Oh, the people.
Because the people did it.
The people did it.
The people are responsible.
Yeah.
So always try to get the name of the court recorder, the judge, the registrar of the court, or the parties that are giving you some sort of grief. And those are the parties that we can go after, and we can go after the corporation as a whole.
Right.
Right. And if you see, we'll get to this in a minute. You'll see where this comes in handy. Okay. Now, this is another one. Okay. Done without indicating inner secrets. And basically, you're supposed to know the consequences of your action. That's what it comes down to with this legal maxim. So in order to fix your wrongdoing, as I said before, you don't want to go right directly to court. You want to give them an opportunity to rectify the problem. So if I tell you you've done something wrong, you're violating section ABC of the 123 Act, you have an option now to fix it. But
this
if
is
you
well
don't,
before the court by letter.
By notice, not
by
letter.
Notice.
Letters can be thrown in the garbage.
Oh, right. Okay. By notice.
So serve them what's called a legal notice. And we can draft up legal notices and post them on your website to help people, give them a sort of a starting block.
Yeah.
Right? So this tells you right there that they're supposed to know their actions, but you can't necessarily fault somebody for not knowing. But if you tell them you're breaking the law and they continue to do it, well, then, hey, you now have a legal recourse. They know and they did it anyway. That's the purpose of our legal notice.
Right. Yeah, we're telling them.
Right. This legal maxim that says no one except before God. The legal maxim denotes any accused person is entitled to make a plea if not guilty. Okay? And a witness doesn't have to give a response to something if it's going to, mess up his case. Now that doesn't mean you can't, or are not supposed to tell the truth. If you're asked a question and it's going to incriminate you, well, if they force it out of you, like a lot of times you're coerced by the police or court people to divulge information that you might not necessarily would have done that. So if you do something and it's done under threat and duress, you must have heard that term.
Yes.
So something that's done under threat and duress is not legally binding if you can prove it. Right? It says here, refuse to call on a man who accused himself and shall not admit his confession unless it's shown to have been made freely. So this is the argument. If you're coerced into something or to signing a document or to stating something you're not, you wish you hadn't said, you have a recourse. Now that doesn't mean spill the beans and then try and fix it. But if you made an accidental error, then you might have a chance to fix it.
Yeah, if you can prove it.
If you can prove it. The onus of proof on anything is before the person making the assertion. Right? This is where we got into the other day. And we'll get into it in a minute. But when council tax comes along and says you owe this bill, okay, you're asserting I owe this bill, then prove the obligation. And once you start going down that rabbit hole, they can't prove anything, and the case should disappear.
Right.
I would really like to do a presentation on council tax, which will address this specific points within the regulation itself.
Well, we'll do it. I think it would be good to have the resources available so that people can follow that and get clued up themselves.
Right, and I have that presentation already done and waiting for you.
All right, there you go. One step ahead.
Sometimes, not always. Okay?
Yeah.
This is another legal maxim. A provision of the law shall not, it's cut off, but I think it says deprive.
Depart. It says, yeah, provision of the law shall not depart, or from the words of the law there must be no departure.
Right. This maxim basically depends on the interpretation of the statute. And many times what the courts will try to do is they will read only specific sentences within the statute, and it may even be a subsection of a statute, which is not correct. I mean, this happens all the time.
Does it?
So, yeah, like, for example, I can give you an example in, back to our Ontario law, but under Section 15 of the Building Code, it says the chief building official has roles and duties of plumbing and sewers. That's under his general duties, but yet they go to push this bylaw through under Section 15, and it says Section 15 must confer with 9, 10, and 11, and Section 9 is a natural person, Section 10 and 11 deal with economic development and public assets. So based on that, how do they have any jurisdiction on private property? But see, they leave those parts out, and then they push through some bogus court case, and then you have to go along and try and fix it.
Right.
Which means you have to now appeal it to a higher court. In our case, it's divisional court. And here it would be the high court and then, the administrative court if it deals with council tax. So make sure that when you read the law and you try and quote sections of the law, quote the entire section so they can't just rip it apart and say, well, see, under here we can get away with this. Because this is what they try to do.
So you need to be able to find those laws to be able to quote them back at them and say, I understand this is the law, quote, end quote.
Yep.
So that there is no wiggle room that they can say that no, the law is this because you've quoted it verbatim.
Exactly. So what I do is I give my interpretation of the law. Like I would, in that particular case that I referenced, I would say the chief building official does not have the ability to issue an order related to property standards issues on private property pursuant to Section 1, sub 1.3 of the interpretation under the building code, which limits him to sewers and plumbing.
Right.
And you quote it right out of there, and you tell them where you got it from. It's the 1982, or I think it is, building code. So under that, they're done. I mean, how are you going to argue with what the statute says?
Yes.
So
it all comes back to the statute. As long as you can quote it and find it, then there is no wiggle room because you're staying within that statute. They can't fight against that because you've told them that you know it as well.
That's right. So if you recall from our first presentation, I said that the courts get their jurisdiction from three things: primary legislation, and we can do a separate presentation on that, and secondary legislation. And so when we're quoting the Building Code Act in Ontario, that's secondary legislation. When we're quoting the council tax and administration, that's secondary. When we go out over the enforcement of the council tax, that's all secondary legislation. So if you quote it, and you quote the Senior Courts Act, for example, how are they going to tell you you're wrong? The statute says I'm right.
Yeah.
Right. So this is why I said the other day, you don't want to go in there with some, free man on the land and, I put my thumbprint and all, because you're not basing it on law. And if you have to appeal any case in court, whether it's in Canada, UK, US, I don't care, you can't bring in new arguments. You're not allowed to. You should have done that properly when you did your first case. But if you can show there's an error in law based on the statute and based on what was previously filed, then you have a chance to get this in front of a court. But if you start bringing in all kinds of new legislation, new laws, new rules, new regulations that you didn't do previously, the judge is going to say none of this was before the court. The court didn't make any errors based on your Meads versus Meads stupid arguments. The court was right. So always go back to the statute. This is where most people make their mistakes.
Right. Okay.
right?
Yeah.
Now, intention to harm. This basically is an argument you might use against the judge, because the judge is trying to back the solicitor working for the city or whatever. And basically, if you intend to break the law, right, and you try to do something which you know you're committing a crime, and the person knows that the law forbids this action, and they know what the outcome will be, right? This is a legal maxim. You can say, well, the city bylaw officer lied, or the council tax person lied, the legal advisor lied. You know, we don't call it lie, we call it perjury, but I'm just speaking English.
Yes.
None of this legalese garbage. And so this is a legal maxim. Now, I also said earlier that one of the first maxims we covered, the court has an obligation to fix it, right? So
Right.
if they see, when you go to court, if you know there's something wrong, the person committed fraud or they committed perjury or something, the judge may know it too. But until you bring it in front of the judge and say, hey, look, this is the violation, they just did it, then the judge has an obligation to do something. Otherwise, if the judge was to step in on your behalf or on their behalf, he's practicing law from the bench. That's illegal.
Yes.
So you have to bring those arguments. And you try to do it, as I say, in paper. Because when I write a 478-page document against the city or the municipality, and it's all in affidavit format, and we'll get into writing affidavits in a different presentation, it's their job to rebut it. And I can't obviously sit on the floor of the court and start reading verbatim out of a book.
No.
That's why all your paperwork has to be done in writing, and then you bring out the key points when you make your oral arguments.
Right. Okay.
See? Now, earlier in time, stronger in law. This is where we go back to the precedent case law. If you can find a precedent case law from, I don't know, Richard, how about 1866?
Sounds
right?
good. Yeah.
Right? There's your primary legislation. It stands as fact. It's been around for, 100
Yes.
years, right?
Right.
Over
that makes sense.
100 years. So now we're going to use this primary legislation, or we're going to use other precedent case law. For example, and I'll give you a case which may help a lot of your viewers. It's R versus Lee, and Lee is spelled L-E, not with two E's, just one. And in this court case, R versus Lee, it's a Supreme Court of Canada case where a search was done on this person's property. The officer went around or scaled a fence, I don't remember, went to his backyard, and they found out this guy had alcohol, I think, and he had drugs, and he had a gun. Well, they should have been able to charge him, but this went into the Supreme Court of Canada, which means it was appealed a few times. And the judge said, no, the search was done illegally, therefore the findings are also inadmissible. So anybody that's getting bothered and with something that search that's done illegal, and this goes through to your, like, if vehicles are seized on the highway.
Right.
If an officer tells you to step out of your vehicle, lock the door. He's going to say, what are you doing? I'm securing my vehicle. Otherwise, if you don't secure it, it's marked abandoned and they search your vehicle. And then if they find something, well, then you've got problems.
So when when you do step out the vehicle, but you lock the door, is that what you mean? Or you lock the door inside the vehicle?
No, you can try that. But if you step out of the vehicle,
right,
lock the door so it's
Yeah.
not abandoned.
Right.
And a cop will say, well, what are you trying to do? What are you doing? I'm securing my vehicle. You've asked me to step out of my vehicle.
Yes.
Which technically isn't your vehicle anyway. We'll get into that some other day.
Yeah.
But the thing is, if you don't, they'll put you in the back of the cop car. They'll search your vehicle. And in some cases, I've even known evidence to be planted in the vehicle so they can get a
right. Yeah. So locking that, they cannot do that unless you willingly unlock it for them.
Right. And if they turn around and search you and take your keys, well then, okay, that's assault for one, and then it's also an unlawful search. So if it's an unlawful search, R versus Lee, the case I just gave you, would save your bacon.
Right. Yeah. Brilliant. Okay.
Yeah. So prima facie evidence. Okay, this means in layman's terms, if 90% of what you said was correct, and maybe you can't verify one or 2 points, well, more than likely, what you said is correct because everything else is correct. Now, when I dealt with the local municipality, I got the city solicitor, telling things that aren't correct. I've got the city bylaw enforcement officer telling things that aren't correct. So they've committed perjury, and the judge allowed it, even though it was brought out in public. But now, because they've made false statements, they've committed perjury. They're a non-credible witness. If you can cross-examine, and you may have to do this, if you can cross-examine somebody and you can prove where they're not telling the truth or where their story changes, then more than likely, on prima facie evidence, as we call it, if that part of the statement is incorrect, then probably the rest of it is too. And under the Evidence Act anyway, perjury is not allowed in the court. So once you've lied knowingly, I mean, if you make an honest mistake and say, yeah, it happened on Tuesday evening and you meant Wednesday evening, well, that's a simple mistake. But if you outright lie to try and cover up some criminal wrongdoing, well, that's totally incorrect. So now you're a non-credible witness. Anything you say can't be used against you, or can't be used in court. So prima facie evidence comes into play here, because if prima facie evidence indicates that the officer told a lie 2 or 3 times, 4 times, whatever, then, you know, more than likely everything else they said's crap. So you ask for a motion to strike because you have a non-credible witness.
Right.
We can go through simple court procedures in a separate presentation. Like I said, I can keep you busy, and I don't mind doing this because people have a right to know, right?
Yeah. Well, that's very generous of you. Yeah,
no problem. It's through the lack of care, okay? This is another maxim. If the court omits or to consider a binding precedent case, in this case, based on the same issue, or if they willingly disregard sections of the statute, then the whole case is void. And here's the evidence, or the maxim in law that proves it. Yeah.
Yeah.
And so when you do this, if the court considers, if it considers the case and it considers the maxim, you're okay. But if a lot of times they don't, here's a court case that says they have to. And many times they don't, believe me.
It is amazing that they I mean, I suppose they get away with this because they can.
Well, ultimately, I mean, they can do anything, but whether it's legal or lawful, that's another story.
Yeah.
And sometimes you have to appeal it. You may have to appeal it 3 times. It's a big pain in the keister. When I used to tell people, if I'm going to work on a case, and I've done lots of them, plan on the next month of your life going down the tubes. Because especially if you plan on doing it yourself, because you got to dig all this crap up, and then you got to learn how to file it, the proper forms, do the proper layout, do the proper filing, and you got to do it within a certain time frame.
Yeah. Why would you, to interrupt this then, why would you do it yourself? Why wouldn't you just hire a solicitor or lawyer or whatever to act in your behalf?
Very good question. And that's probably the best question of the week. Because if you hire a lawyer, he has an obligation to who? The Bar Society and to the courts. And his job is to generate revenue. So if he represents the Bar Society and the Crown before you, well, isn't that a conflict of interest?
Absolutely, yeah. I thought you were going to say that because that's what I've been told, but I thought it was clear to the audience to know that. So the reason to this can be quite daunting for people at the beginning as they listen to this and think, oh my God, this is so complicated and there's lots of it. But as you so rightly say, if you think you just pass it on to and the other thing is you're paying for that, aren't you? You're paying for someone who's not quite on your side.
Well, that's it. And like in the case, I can go to the Ontario case because I've worked on it recently. Lawyers, at least in Canada and in the States and probably here too, they're licensed to what we call practice law in a certain area, certain district, if you will. So if I go to an Ontario lawyer, they can't help me with a case in a different province. If I go to California and I want somebody to argue a case in Indiana, different state, can't do it. If I want somebody to operate and help me with a case in Wales, I probably can't get them to do it if I hire them from where I am in England. It won't work. They'll stop it. They say they're not licensed to practice law. And the thing is, some people say, well, I know what I'll do. I'll get my buddy to help me. I'll get my friend. He knows what he's doing. We'll get him to help me. No, the courts are clamping down on that. They don't like self-litigants, and especially when you hire your buddy. Now, there's some people that, when I dealt with the Ontario courts, what I did was I went and got a directory of all the lawyers in the province of Ontario. And the province of Ontario is a big province. If you drive across it, it's going to take you probably about 30 hours if you drive the speed limit. And that's just to go straight across. So it's a big place. And none of the lawyers that you deal with necessarily want to deal with your case because they're going against the system. And there's the biggest problem. They're going against the system. If they prove, for example, in Ontario, that a person doesn't have to pay property taxes, right? Which they don't. It's under Section 17 of the Municipal Act. Do you think the lawyer's going to expose that?
No, no.
And when the city puts a lien against your property, they can't do it. They're violating the Land Titles Act in about 4 places.
Right.
If the city comes on your property to do a cleanup, and they call it a community improvement, they can't do that under Regulation 322/12, Section 4. So if you bring this to a lawyer and you say, well, here, they can't do this, the lawyer comes back and says, well, yes, they can. No, they can't. Go read the stupid statute. It's right in front of you. So you're better off to do it yourself because you have a vested interest. The lawyer's going to charge you $1,000 or £1,000 retainer fee, and they're certainly not going to look into the thing the way you did.
No.
That's why, like, a normal affidavit filed by a lawyer is usually about 30 pages. When I file an affidavit in court, it's about 450 pages. So who's done more work?
Yeah.
And you can't tell me, even if I make a mistake, you can't tell me all my points are wrong. If the municipality goes to seize your vehicle, they can't do that either under Section 50 and Section 63 of the Municipal Act. So they can't take your vehicle off your private property because it has no plates. And if you look under the Highway Traffic Act, under Section 7, they can't seize a vehicle for not having plates. It doesn't require it. And I got a letter from the Ministry of Transportation that says it.
Right.
So how? Yeah. See, I had to do some footwork. The lawyer's not going to do that.
No. So I absolutely see how it is so beneficial for people to do it themselves, even though it can seem quite daunting.
Right. Exactly.
But the outcome is more likely to be in their favour if they've done their due diligence, if I can say the word.
Yeah.
Or the words.
Words. Yeah. If they do their own paperwork, and that's the other thing, the paperwork has to be on the correct format. You just can't file whatever you want in court and say, this will work, because the courts will reject it. But we can do a presentation on court paperwork at some other time.
Right.
Like, I'm all for helping people because the system's gone squirrely, basically, long enough.
Yeah.
Right?
Yeah, we appreciate it.
No problem.
Let's get back. Yeah. I'm just thinking time.
Yeah, no worries. Okay, right here. Here's another one. The legal doctrine obligates the courts to follow historical cases. Right? Remember I was talking about precedent cases. Here you go.
Yes.
The standing of the decided, okay?
The standing of the decided and the do not disturb the calm. Okay.
Yeah. In other words, because this has already been presided over previously, don't go trying to mix up messy the waters.
Right.
It's the same thing. They have to follow similar cases with similar scenarios, especially if it's from a higher court. Binds the court to follow the legal precedent.
Yeah.
See? The reason
it can take some time to sort of, understand the meaning of this and get this into your psyche, because sometimes you read it and you go, what the hell does that mean? Especially if you've gone through several of these.
Exactly, and like I say, there's thousands. But with that sheet that I gave you, that PDF file, it explains roughly what this is. That's where this text actually came from.
Right. Oh, okay.
Okay. The reasons for the decision. If a judge gives you a case and says you're wrong or you're correct or whichever, they're supposed to give you the reasons for the judgment. Well, when you get to counsel tax, there is no reasons because the other side hasn't even presented a case. This is why I want to tackle the ULEZ cities. And I want to tackle council tax.
Right, yeah, and I think a lot of people will be interested in that because they're desperately trying to find a way to fight it, and just chopping the cameras down is probably not the best way of doing it.
I actually have the silver bullet to this ULEZ city stuff.
Superb.
Yep.
The silver bullet.
Yep. Now, a lot of times what they'll do, rather than read all this, it says at the person. And so what they'll do, and they've done this in council tax and other cases, is they will start arguing you're an opto pseudo litigant, or you're a free man on the land, or some other thing. And what they're doing is they're actually misleading the court down some different avenue, because they don't have the wherewithal to argue against your case. Especially if you did as you said, and you enter your case with, here's my understanding, and here's the case rules, and here's the statute to back up my claim. Then they're up the creek. I've had lawyers come back and say, well, the way you wrote this, we don't know how to defend it, Your Honor. Well, good, then I should win.
Yeah.
Right? But what they'll do is they'll misguide the court and say, oh, that's an opto pseudo litigant, that's a free man on the land argument, and the dumb judge will generally go along with it. So right. you have to turn around and get rid of that crap and say, no, Your Honor, I didn't use any of the arguments in the Meads versus Meads case, because that's the common one they use. And so that statement is defamatory, and it's to mislead the court, which is misconduct. Right?
Yeah.
It's contempt of court by an officer of the court. You basically just stepped on that legal person, legally and lawfully. Right? Because you're showing where they're making, false statements, which actually is defamation of character. It's perjury.
Right.
So
yeah.
I gave you 3 arguments as soon as they bring that crap up. Now, damage without an injury. This is another thing. A lot of people think that, and a lot of people have said to me, well, I wasn't injured. Wait a minute. An injury is basically an infringement of your legal right. So if somebody's done you wrong and deprived you of due process of the law, that's an injury. It doesn't have to mean that you're bleeding on the ground.
Oh, right. Okay.
Right? An injury is anything that's done against your legal right, or against your, and I hate to use the word, person. Okay? There's loss of money, loss of comfort, loss of service, loss of health,
Loss of time, presumably, if you're late for a important, like an airplane.
Yeah.
Or a trip somewhere, or your, surgery.
Exactly. So if you get harassed, just keep track of the person's name, and you do have a right to a remedy. Okay, I'll get you to read the top of that.
An act does not make a man guilty unless there be guilty intention. Exactly.
Now this goes back to our council tax issue,
right?
Or it goes back to our property standards issue in Ontario. If you don't intend to break the law, right? If you're not intending to break the law, this is why the other day I said ask a question.
Yeah.
Because you're not intending to break the law. You're just asking a question for clarification. If you didn't intend to break the law, then you're not guilty. Like I can give you one case where, in fact, it was my case. I was going back from Alberta to Ontario, and a police officer speeding well in excess of the speed limit catches up, and he gives me a speeding ticket for going 1 kilometer over the speed limit. Obviously, I did not have the intent to speed, and it's 1 kilometer. What the heck are you doing? So I went after the RCMP.
RCMP being
Royal Canadian Mounted Police, and I went to the guy on top, right? Went to the top of the heap, because this other guy wouldn't identify his name. So I said, "This is what happened, and if you want me to attend a court hearing, you're going to have to give me a prepaid check to cover the expenses, because obviously 1 kilometer, I got a $752 ticket, which is ridiculous.
Yes.
I mean, 1 kilometer." So when I was done with it, I eventually went after this guy's bond, and now he doesn't work for the RCMP anymore. But because if you attack their bond and their insurance company, we'll get into this at a different time, it basically screws them up. And that's good, because if these people were stepped on, then maybe they'd start following the law. They want to step on our rights. Well, guess what? Yeah. I'm going to use my rights to step on your ability to do this.
So when you said what you mentioned in the council tax, if you're they've given you the bill, whether that's right or wrong to give you the bill, let's just put that to one side.
Yeah.
And you go back to them and say, well, I have every intention of paying, but I don't think we've negotiated a contract here, or I don't know how you've come about by this sum of money. So if you could make that clear, where the contract is, or where I signed, or whatever your question is, that's shown that you're not being guilty, because there's no guilty intention to not pay. You haven't said you won't pay.
Exactly. So what you do is you would question the legality of the proceeding.
Right.
And if you can question, and that's based on this, what I was referring to the other day, is the yellow paper, which we will go through.
Yeah.
And you will see that this is not lawful. So if this is the way the court is operating, and it's operating outside the Magistrates Court Act or the Senior Courts Act or civil court procedures, then how is the finding in this hearing, and how is your council tax legal? And they can't answer it because you're going to use the law, the statute against them.
Yeah.
Right?
Yeah.
So you're not, and the thing is, you're not guilty of anything. You're just simply asking a question.
Yes.
Right? I just want some clarification.
Yeah, people must not be frightened of asking a question when they see, say, a summons, which sounds very threatening, but they can ask a question in response to that instead of just acquiescing.
Exactly. As I said earlier, when we dealt with our other presentation, if I want to bring you to court for a specific reason, I generally try to negotiate with you to see if we can resolve this without wasting the court's time. This is called mediation.
Right.
So if you send them back a document and say, well, I don't believe this is legal, kindly answer it. They probably won't, because they can't. And then if they find you guilty, well, you've already proven ahead of time where the conduct of the court is illegal. So this would now give you grounds to appeal. Now, a lot of times what they'll do is they'll say, well, we don't care about that, and the court never got it, and all this other garbage. But that's because when you serve paperwork into the court, so to speak, for council tax, you don't really serve it into court. You serve it to the council. Well, the standard way court procedure works is you would serve a copy of whatever your argument is to your adversary, and you would serve a duplicate copy to the court, and you'd file a certificate of service in the UK, or an affidavit of service in Canada. And that would say, I've served this document to the other side, and we're giving them a chance. Now, in a normal court case, somebody may argue the point, but who cares? You generally give the other side 28 days to respond, 28 to 30 days. Well, if they don't respond, let's say I'm taking you to court for some reason. I don't care what, it doesn't matter.
No.
So I write you the paperwork up and I send it into you, and I basically give it to you. And first thing I did was I got a court file number. And I put that court file number on your documents, and you turn around. When you correspond with me, you put the same court file number, and we correlate back and forth. Right?
Yeah.
And this gives the court an idea of what file is it and who's involved. Well, when you deal with this council tax crap, there is no court file number.
Oh, right.
And there is no court record of it either. They tell you to go back to the city council and get the court record from there. So okay, now you're not following civil court procedures. So is council tax a valid court argument? No. We'll get into that later. But the thing is, I can show you where the council tax is totally unlawful.
Excellent. Look forward to that one.
But we'll stick on this legal maxims.
Yeah.
Guilty act, the act that proves criminal liability. So if the municipality, let's say council tax, is doing something, and they know because you pointed it out in your paperwork that they did something illegal, it's a guilty act. They knew because you warned them.
Yes.
The same thing with property standards issues in province of Ontario. It's unlawful if you warn them and they do it anyway. Now you have legal recourse. Ignorance of the law is no excuse, but I did you a favor. I told you were breaking the law. I showed you, and you went and did it anyway.
Yes.
So now you put the upper hand on your side of the table, not on theirs. A lot of these people, they don't read. They just, well, this is what we did last week. This is what we're going to do this week. And they get away with it.
Yeah.
Fraud and justice never dwell together. So if the city or the municipality does something fraudulent, right?
Yeah.
Okay, it corrupts the whole thing. So if they're not operating in good faith and they intend to mess you up by lying and committing perjury or withholding evidence or misleading the court or attacking the person, as we went earlier, that's fraud. And fraud doesn't, by the way, guys, fraud doesn't have an expiration date. So if somebody's committed fraud and you've been paying council tax for the last 30 years and you can prove it's unlawful, you have a right now to go back and collect it. If you've been paying property tax in Ontario, okay, under Section 17 of the Municipal Act, it's right there in black and white. They can't impose taxes, so what are they doing? That's fraud. You cannot knowingly engage with a company who commits fraud, because then you're aiding and abetting fraudulent activity. So now you have legal rights to withdraw. So if you go back to our earlier presentation where I said that the municipality, a certain municipality, was engaged in investing, now divesting, in arms, right? That's military stuff.
Yeah.
Okay? They're knowingly supporting an act of war. There's a good grounds for not wanting to pay your council tax now, isn't it?
Absolutely. Yeah.
There you go.
There you go.
This fraud thing goes on further. We'll cover it on another one. Law or a right does not arise from an injustice. So if they do something that's illegal, right? They break the law. It doesn't give them the right to do something because it's injustice. They did something illegal, right?
Yeah.
Okay. There is no wrong without a remedy. There's always a legal right, and if there's a legal right, there's a remedy. So if the court screws up and does something fraudulent, oh yeah, fraud doesn't have an expiration date. Go after them, right?
Sorry, when you say go after them, I mean, people often get a bit worried because they think the cost of taking anybody to court, especially larger organizations than themselves, them being an individual, is what would make them frightened in case they're going to lose or at the end of the day mess it up because they're nervous and that sort of thing. So although you say, the fraud, whatever it is, go after them, how do you reassure somebody that it is actually worth going after them and not to overly worry too much? Because, not everyone's got a big pot of money to go to court with.
Right. Well, here's the big thing. If you hire a lawyer, right, as we already covered, they're going to want $1,000, £1,000, £1,500, $2,000, £2,000 retainer fee.
Yeah.
Well, when you have a retainer fee, you just threw money out the window. You don't know how it's being used and what the time frame is and all this. If you go to file a basic case in court, it costs you maybe £300, or $300. Doesn't matter, depending if you're Canada or UK. So it's not a huge expense. And if you know your facts and you got your stuff all straightened out, ahead of time, then if you win your case, you get those costs back.
Yeah.
However, if you lose that case, remember the expensive lawyer over there, he's charging £320 an hour or whatever, $320 an hour. When you're working for yourself, you're not charging yourself. So you got to learn this stuff. But at the end of the day, if you win back all the taxes that you paid to council, or you win back all your property taxes, which never should have been charged in the first place, that's going to make a huge difference. Because, if you've lived at a property for, 30 years, you might be getting back $64,000. Who knows? So is it worth the investment? But know that you're in for a fight because they're not going to want you to admit the truth. Right?
No.
So the best thing to do, as I said earlier, is download the statute ahead of time and do all your preliminary paperwork before you attack. Right? If you're going to war with somebody, you don't go, okay, we got one tank and it's semi-working, doesn't work very well, let's go to war. No, you fix all your equipment, you make sure everything's good to go, and then you charge on, and then the other side goes, holy lift, what the heck is this?
Yeah.
A 480-page affidavit. Well, how the heck? Oh, yeah, you got 30 days to respond to it, 28 days. How are they going to respond?
Right.
Right. Now, if it's important, if you're dealing with an important case, like somebody's at risk, child's at risk or something like that, you can put an application into the court, and this is what a lot of the slimy lawyers do. They'll put an application into the court, in which case you got 10 days. Well, keep in mind, it probably took me 30 days to write that affidavit, and here's some lowly, clerk of the town. He gets this book, and holy crap, they got 10 days to answer it. Whoops, oh man. Good luck, buddy. This is what they try to do to you. They try and jam you up for time.
Right, yeah. Well, that makes, So you can use it's the same principle then. You're using their techniques against them. Right.
Now, in this court case, and I've done this throughout the thing, we haven't covered it yet. If you read the bottom line there, right, it's whatever versus whoever, and then it's got the date, and then it says SC.
Yeah.
SC is Supreme Court.
Right, okay.
And then you might have CA, which is Court of Appeal. Because we're referencing, in this case, we're referencing U.S. law.
Right.
And if you click the little blue link in the PDF file that's been provided, it should bring you to that case unless it's been moved.
Right. Oh, okay.
So
I went to click the presentation. Such a fool that I am.
that's all right. It doesn't work here.
No.
Okay. What's this next one that tells us here?
Foundation being removed, the superstructure falls.
Right. So if the whole case is based on acts of fraud or misleading information, the whole case falls apart.
Yeah.
Right.
This is reassuring. This is very reassuring because it does put the power back into those, because when you don't know this, of course, it's all very frightening. It's all in legalese and it's all very official, and these people all dressed up in their theatrical costumes make it seem much more intimidating than ever. But going through this, I know some people may have gone, oh, this is a bit too much for me. But, what you're showing and demonstrating here is the ways that, just that, if the foundation being removed, the superstructure falls, which then is a statement of the obvious, really. If you take away the walls of a building, how the roof is going to collapse.
Exactly.
And if the case is built up on a complete load of old nonsense, then it's going to fall one way or another. And if you're in the know that's the event, then you can point it out.
Right. So Richard, where would that be applicable in the UK?
Well,
council tax.
Council tax, yes. I was just trying to think of something other than council tax,
yeah.
But yeah, that's a good one.
Yeah, and the same thing in Ontario. They're charging property tax. They're not allowed to do that. Right, and we've now disclosed it. So hurry up and download this appropriate statute before they revise it.
Yeah,
that's why I said get your statutes in order before, because even if the statute's been revised, you can still refer to it because at that time it was illegal. And if it's illegal, that's an act of fraud, which doesn't have an expiration date.
Right. Yeah.
So and that goes back to precedent case law. We covered that earlier.
Yeah.
Right? On to the next one. He who asserts must prove. This is a great big one for council tax because they didn't prove your liability.
That's
right?
it. Yeah. Now there's a chap, I won't mention him. He does a bit of martial arts, and he's a barrister, and he has a YouTube channel. And he has put up videos about anybody challenging the council tax, because he says that it is legal and there is a liability order for this. And he always just points to I forget the name of the act, but there's some legislation, and he says it's basically there because we say it's there, which is a sort of circular argument, doesn't prove anything. Nobody's actually negotiated, no one's signed a contract, no one's asked to have it.
Right.
And you would think that you would be able to be born on this planet and live under a roof without somebody coming up to you and saying, you owe us some money. Just for that, something that you couldn't help.
Well, the thing is too, under the Local Government Finance Act, which is the one you were looking for,
right?
If you check that, certain properties are exempt. Somebody might want to look into that.
Oh, right.
That's a clue. That's a clue for homework. That's a homework assignment for the viewers.
Yeah, you'd be very pissed off if you'd been paying for 30 years and you were completely exempt.
Exactly, but that would be an act of fraud. You have a right to request that back, and if they give it to you, great. If they don't, you can take them to court.
Yeah, blimey. There you go.
There you go. Okay, what's this thing say?
Actor rests the burden of proof.
Isn't that what I said earlier? Burden of proof lies on the plaintiff.
If
the plaintiff is bringing you, or the claimant, if we use UK language, okay, if they're claiming something, they have to prove it beyond a shadow of a doubt, or more than likely this is correct. Well, guess what?
So they have to prove. So going back to the council tax, they have to prove that you owe them the money, and they can't prove that. They just point to the Local Councils Act that you said, and legislation or whatever, but that in and of itself is not proof. That's just something somebody made up.
Yeah. So prove that applies to me. We can't do that. Well, it applies to everybody. No, it doesn't. In fact, if you read the property tax thing in Ontario, they're not allowed to regulate a dwelling unit of less than 6 six dwelling units, which means it's commercial. So yes, I agree that the municipality may regulate certain businesses for consumer protection. There's a clue for you there in council tax too, right? They can regulate certain things to protect the private individual. Now look what this thing says: every plaintiff at law or complainant at equity. Well, who's got equity here? Does the city have equity in your property? No. Maybe they may maintain the road, but they don't have anything to do with your property. So you have an equitable claim. And the same thing with your vehicle. It's registered to DVLA. We have to correct that mistake. Somebody gave away the ownership, but we can do that. We can cover DVLA in a separate thing. But you have an equitable claim. So it says right here, at equity, must show a good title or claim before he can prevail in a suit. Well, you have equity. All you got to do is dig up a receipt for a repair bill.
Yeah.
Right? You painted your house. Here's the price of the paint. Here's the price of some wood. Here's the price of my new window or something. Whatever. So equity trumps all in law. What equity does the city have? None. Now,
interesting. Yeah.
And here's another good one. What cannot be done directly cannot also be done indirectly. So if they can't get you one way and they try to lie and cheat and bend the rules and all this garbage, and the statute, which we're going to call law for now, says that they can't do it, well, then they freaking well can't do it. Right? So they can't say, well, that law says this, but this law says this. No, then there's a conflict.
Right. Yes.
Right?
Yeah.
Well, where's the conflict, Richard? Oh, how about primary legislation?
Yeah.
See? Primary legislation says nothing can be done to the prejudice of the people. Now we're going to use this maxim in conjunction with our primary legislation to assert our rights. It all ties together. One making a contradictory statement is not to be heard. So if the city says one thing, the city person says, well, your vehicles are derelict because they don't have plates. And then they say, well, they're derelict because they haven't run. Right? In 2 years because you've been harassing me with a legal suit. Well, yeah, right. But you said they were derelict because they didn't have plates, and I proved that wrong. Right? So if they're fish people, as I call them, flipping back and forth, then they can't do it. And this is a legal maxim. Don't take my word for it. I've given you the court case. You can reference it all. Right? So if they're making contradictory statements, like one of the things for council tax, the legal advisor said, well, it doesn't pay for any specific product or service. Okay, great. And then if they come back with a letter that says, well, it pays for the maintenance of the road. Actually, that's incorrect because that's done through petrol tax. So now you're making contradictory statements, so you're non-credible. You can't be heard. And you just throw their case out the window. Right?
Yeah. So it's interesting because everybody assumes, I say everybody, that's a sweeping statement, but a lot of people assume that the law is there against them. All these laws have been there to favour authority and government and stuff. But actually, in many ways, these laws, as long as it's fair, it's there for both parties. And if your party is the innocent party and they're just taking you for a ride, then it is actually on your side.
Yes, but they're changing the laws over time. And this goes back to our legal dictionary. When we said the Black's Law Fourth said this, and now it's something different. So they're slowly encroaching on your rights, and most people are asleep and don't know. So here's one for you with the court. Let's put this into the court. If you read the top line, I'll take care of the bottom.
Acting and consenting parties are liable to same punishments.
Right. So if you bring a court case into, let's say, council tax, into the bogus magistrate court, and they're aiding and abetting, in other words, forcing you to pay some criminal thing, those people within the court are just as liable as the person who made the argument.
Oh, right.
So now it gives you the door. The door is now open for you to go after the, usually it's the legal advisor in the case of council tax. And who's the legal advisor? Who does he work for? Go figure that out. Right?
Yeah.
Right. So if the court does something like in the case of property tax, if you go into an Ontario court, and we'll deal with it separate with Ontario, but if you go into court and you prove that they don't have the right to charge property tax under Section 17 1 of the Municipal Act, and they don't have the right to regulate the licensing and parking of motor vehicles under the Municipal Act, Section 50 and 63, and they have no right to do a local improvement on your private property without your consent under Regulation 322.12, and they go do it anyway, and they authorize the municipality to trespass on your private property, which violates the Trespass to Property Act, and they steal something off your property, let's say a vehicle. They just violated 50 sections of the criminal code. Well, guess what? The judge is just as liable
Right.
as the party that did it.
Yeah.
Right? And those sections I quoted within the law are, in fact, the law in Ontario. It's not my, speculative or made-up scenario. What I'm quoting is the actual law, and you notice how fast and how easy I know the law.
Yes.
You have to know your case. If you're going to argue a case, you have to know pretty much your case, because these people will throw some garbage at you, and you can say, well, yes, but under Section 50 and 63, they can't regulate the licensing and parking of motor vehicle. Yeah, well, the building code says they can. Okay, the bylaw says they can. Yeah, the bylaw might say they can, but if there's a conflict between the bylaw and a statute under Section 14 of the Municipal Act, the extent of the conflict makes the bylaw inadmissible. And further, the bylaw was all passed on the same day without public input, which violates Section 238 of the Municipal Act. So I don't care what your bylaw says, it's irrelevant. And under the Highway Traffic Act, Section 7, they can't do it anyway. Now the other side's going, oh, what the heck do we do? Because you just buried them under their own statute.
Yeah.
Those statutes, by the way, those are the actual statutes.
Yeah. And so, I don't doubt it, Stan. I don't doubt it.
Right. Now, earlier I said equity follows the law.
Yeah.
This is a concept that equity or law will not aid a person or party who's at fault. The law will not aid a person whose own fault it is what made the legal action necessary. Well, this is important because remember, I said we want to try and mediate before we litigate. So if we try to mediate with council tax, or we try to mediate with the property standards people within a certain municipality, and they choose not to do it, and they bring you to court and say, well, you're liable for all these legal expenses. No, because equity follows the law, and the law will not aid a person whose own fault it is what made this legal action necessary. Yeah. So now you're not on the hook because they decided to try and run you over, right?
Yeah.
So now you have a legal recourse to say, no, I'm not liable for any of this crap. You guys didn't do the mediation, which you should have did, and I showed you where you were breaking the law, and you chose to do it anyway. That's not my fault.
So a lot of this you can point out to them in advance so that they know that you know what you're doing.
Exactly, and hopefully they'll give up and say, okay, we're going to have a meeting and avoid court.
Yeah, because if you can avoid court, obviously it's a better outcome for everyone.
Yeah, if you can do a simple letter writing campaign back and forth 3 or 4 times and be done with it, why not?
Yeah.
Now here's an important one. I'll get you to read the top part because it's cut off in my case.
Okay, it says here, the judges do not answer to a question of fact. The jury do not answer to a question of law.
Right. So if the judge doesn't answer to a question of fact, what's he basing his case on? He's basing it on the statute, right?
Right.
But if you go to the jury doesn't answer to a question of law, they go based on the fact. Well, in reality, they kind of intermix because you can't, they're not regimented into a certain thing. But if the jury is a trier of facts and you show that where you're doing things correctly and you show the law and say, look, says this is a fact. So I'm not asking you to interpret the law. The Local Government Finance Act, for example, authorizes them to take me to court. Okay. But under the Senior Courts Act section, some 109, for example, says that they have to follow this procedure and they didn't do it. So how is that lawful? So now you've used the statute to establish the fact to get your trial by jury.
Yeah,
right?
So I was going to ask you about that actually, because when you go for like council tax and parking tickets and things like that, you're at a magistrate, which is you don't have a jury. That's
right. So you may have to appeal it.
Right.
Right.
And take it up the system.
Yeah, you don't expect the first go around in court to be without a fight, and don't expect that you may not have to appeal, because even though you're right, remember the court's job is to solicit funds. Who's the guy in the court? Oh, he's a solicitor. right?
Yeah.
Right?
Just
They tell you,
illicit
right?
funds.
Yeah. Yeah.
It's all in the wording.
Exactly. Equity looks upon that done which ought to have been done. So this means equity. You have an equitable claim because it cost you something. May not be a monetary value, but it cost you something. So when a person is under an obligation to perform an act, in other words, follow the law, High Judge, equity looks that which allows the same results followed as if it actually was done. Meaning if the court screws up, you have a claim. This goes back to your ability to appeal something which was done incorrectly. And especially if you've notified the court in advance and you did all your paperwork and there's an error in law because the judge or the court screwed up, then you have that right. Mm-hmm. An act done by me against my will, basically, is not my act. This means if you sign a document or you're forced into something, taking a certain medical procedure, for example, then you have a legal recourse, right? If the act is committed and done under coercion or undue influence, such as you'll be fired, then it's not really your act and you have a legal recourse. Nobody can force you into a contract or a medical procedure against your will. And if you did it to keep your employment, well, that's a violation of the Nuremberg Code. And they can't force you to take a medical procedure. But they told you you had to do it. Therefore, this wasn't really your act because you didn't really want to do it. And you now have a potential legal recourse, against your employer.
Yeah, a lot of people might be interested in that one alone.
Yeah, we can, and I got a whole presentation on that anyway. Already set to go. Right to the point, a personal right to possession of property usually arises from a contractual obligation, such as a lease or a title document. A right without possession, is incomplete. So in other words, if the municipality tries to come to you and seize your property due to a council tax bill, they have no legal right because there is no contractual obligation. There is no right. There is no title. The same thing if they try and trespass on the property in Ontario and take your vehicle. Right? They have no title to the document. They have no contract and they have no equitable claim.
Right.
It's 100% illegal. This presentation was brought to you by Denied Truth. And Richard, if you have any questions for me, I'm more than willing to address them.
Right. Let me get back onto. Hang on, I've got to knock this off. Bing, and there he is, ladies and gentlemen. There he is again. Lovely to see you, Stan. Yeah. I think that what you've been going through there will have whet people's appetite. I mean, I know it's a long presentation, and I suppose if you're not going through a single argument like council tax or the DVLA or certain medical things that we've seen in recent years, it can all seem a little bit daunting and a whole load of stuff, and people go, blimey. So to sum up, I suppose, if people have got this far and they've sort of taken it on board, that actually it shouldn't be too daunting. Obviously there's a lot of work involved so that you become extremely familiar with your case, but the incentive to become familiar in your case could be the difference between saving yourself a lot of money, or like in the case of the council tax where you may get 30 years or whatever it is of money back. The incentive to do a good job of it is going to be a lot more than perhaps a £10 parking ticket, which is probably just pay it and be done. But it depends on your ability. You said earlier about people coming in to help you, and the courts don't like that. Say I was being taken to court, hadn't paid my council tax or whatever it was, and I thought, I'm not up to this. And I thought, I know, there's this lovely chap called Stan McDonald. I'll get him down. The courts don't like that. But even though they don't like it, can you still push forward for that?
Well, you can, because sometimes they'll say they give you this argument. And they say, well, you have to, they can't stop you from doing your own case. Okay, you can go through as many legal procedures and, be in court every day for the next 20 years if you want. But what they can do is they can say, hey, this person keeps appearing to help other people, and so that's not permitted. And so in Ontario, they actually had a limit and said a person helping somebody could do up to 6 cases a year.
Right.
But then they changed the rules.
Oh.
But there's a silver lining. If you're fairly disorganized, which most people are when it comes to this court crap, what you can do is you can enlist the help of your friend, and that is a legal term known as Mackenzie friend. So a Mackenzie friend can't address the court. No. But what they can do, if you're looking for documents and you need certain things handed to you so you can make your presentation, the Mackenzie friend can help you. They can sit there. They can act as moral support, and they can help you with your documents. But in no way can they turn around and address the court. That's not permitted. Now, in certain cases, you may be able to appoint that person to help you.
Right. So, I mean, if you were sitting there as my Mackenzie friend, and I was struggling on a thing, and I said, "Oh, just could you pass me the so-and-so document?" You could have written on something on the front of that document that I read quietly to myself and say, "Ask the judge this, and this," and you go, "Yes, oh, by the way, I'd just like to ask the judge about your 2 oaths that you swear at this point," whatever it is, whatever the question is.
Yeah.
And so you'd be able to do that. You'd be able to pass information on notes and stuff.
You can, but what a lot of times when people make this huge mistake, and I've seen this so many times, it's unreal, is they turn around and they walk in and they go, I have my script. I'm going to do this, this, and this. Right. And they go down the script. That won't work. If you're going to walk in with a script, you're going to lose.
Right.
Because they'll ask you a question, and you'll be going, no. Hang on, I'll find it. And you can't find it because it's not there. Yeah. Because you don't know your own case. You have to argue your case, point. And when they throw something at you, like I showed you earlier, yeah, okay, but under Section 7 of the Highway Traffic Act, you can't do that. And if there's a conflict between your bylaw and some statute, Section 14 of the Municipal Act, Section Sub 1, doesn't allow you. It says if there's a conflict between the bylaw and a statute, the bylaw is inconsistent to the extent of the inconsistency or some crap like this.
So if you had a Mackenzie friend before that you were going to bring into court just to assist you with the documents and what have you, it would be a very good idea a week or so beforehand to spend a number of days rehearsing so that your Mackenzie friend can ask you all these questions that you might get, so that you can come back verbatim about the certain act and the section number and all that, and go, yes, well, of course. And of course, in that rehearsal, as you can get yourself more up to speed. And so when you're actually there, the Mackenzie friend, is because you've rehearsed, you have that reassurance. Your confidence.
I'll give you an example on how that may work. And I'm going to use actual Ontario law because I know it inside out. But under Section 9, 9 deals with a natural person. And Section 10 and 11 of the Municipal Act deal with economic development, public assets, and regulating certain businesses. Okay, so if I rehearse this with you and you're dealing with the Ontario court, and Section 17 doesn't allow them to charge property taxes. If you're struggling and you're going, it's a property tax, I could write Section 17.1 and I could hand you that paper. You go, Section 17.1 of the Municipal Act doesn't allow them to charge taxes. Can I sit there and write a whole note and you try and read it to the judge? No. But if you just needed a little
prompt.
Like what is Section? I'll do it to you. What is Section 9? I just gave it to you.
Yeah, I know you did. No idea.
It's a natural person. So if you didn't know and you said, but under Section 9, and I would write 9 natural person, I could somehow put the note beside you and you might look over and, natural person. So a natural person can't bind another person to a contract.
Right.
And then there's Section 10, which deals with, economic development. And then I would write public assets. So I'm listening to the case the same time you are, and I'm making these notes. And if you don't need them, I can just draw a line through it because you've not mentioned it.
Yes. Well, I can see how that would be incredibly useful, and one can practice that as well before. I mean, it makes a lot of sense to as you just so rightly say, you need to know your case 100% so that you're confident that when you go in there, that all the theatrics, because obviously if it's the first time you've been in there, I think you said before a good piece of advice is to go to other trials.
That's right.
Court hearings, and see how it's worked so that it isn't a surprise when you turn up.
Exactly. But the thing is, what I would do if I was the Mackenzie friend, because I'm going to cross-examine and I'm going to basically grill the crap out of you 2 or 3 days in advance,
Yeah.
I would have all those legal arguments on a piece of paper, and I would keep that paper. Now, when you go into court, because they won't let me talk, as you start mentioning certain points, I can draw just a simple line through it.
Yeah.
And then when you go and you get to the end, I hand you the piece of paper. Anything that doesn't have a line through it, guess what? You didn't bring this up yet. So now you've got a backup insurance guy that's doing your job because you're busy scrambling, thinking, and you may miss certain points. And I go, well, you did this. And I can even take the page if I have 2 or 3 of them. And if I don't need it because you mentioned it and it's on a paper, I can take it and just put it aside. Or I can draw a little arrow and put a little arrow on it and say, here. And I'm just handing you one piece of paper. Now, if you keep handing papers, then,
too many times.
You're disrupting the court.
Yeah.
Right. But this is how you can do it. And the judge may get a little, like I had a judge tell me, he says, you're disrupting my court. And I just looked at him because the guy was an idiot. I said, how am I disrupting your court? I said, I'm making notes with a pen. I said, how does this pen turn around and obstruct your court? If you can hear this, you got the hearing of a canine. The judge just looked down and was, kind of ticked off, but what the heck? But if you have the Mackenzie friend with all the notes, he can tick off things as you mention them. And that's a good thing because that way you don't miss anything.
Yeah, no, absolutely.
Now, if the court tries to tell you, well, you only got 10 minutes or something to do this, well, wait a minute, you're depriving me of due process of the law. That's another point. And they'll often do it. And in fact, they're conducting many of these court cases now, council tax and which is UK stuff, and other courts, they're doing it in private over Zoom. Well, one thing you should note is all court cases are to be done in public.
Right. So, yeah. So if it's over Zoom, that's already null and void.
Exactly. Because they're violating the Courts of Justice Act or whatever act it is that we're dealing with.
Yeah.
And court records are supposed to be public. So you as Richard Vobes wanting to do research, if you go into a court, and this is what I started to allude to earlier, sit there for a day, 2 days, 3 days, I don't care, however long it takes you to get the general gist of how this works. And they'll generally call a court case. Richard Vobes versus whatever town you live in, a parking ticket. Oh, crap, that's related to me. Okay. So I write down this guy, Richard Vobes, whoever that guy is, I don't know. I don't care. I wrote down his name. I see how the case is conducted. And then there's some girl that, drove over a flower box because she didn't want to be blocked off her street. Well, okay, I'll listen to that case, but I'm here for parking crap. So I listen to the parking ones and the other ones. And I go pull the court file. And that way I see how the documents are laid out.
And they're publicly available.
They're supposed to be. They're supposed to be. Yeah, and if they try and say, well, you're not entitled to that, well, wait a minute. Court cases are public. And they tell you can't record your court case. Well, actually, you can. I think it's in the Courts of Justice Act, Section 109 for you guys. You can unobtrusively record your own court case. But they'll tell you can't. Well, what are they trying to hide? Right? You have the ability to record your own court case as long as you're not making a bunch of noise and, your cell phone goes off in the middle of a court case hearing and some other crap. So why are they doing that? Then the same thing in Ontario. If you try to retrieve your court records, and they do it here in the UK as well, they'll tell you that you have to get a court order. No, you're entitled to receive any documents provided you pay the prescribed fee. So the court's already operating outside the legal recourse that it has because it's bound by certain regulations. The primary regulations, as we covered earlier, and the secondary regulations. So if they're already operating illegally, like there's one court case here that's dealing with council tax, and the person went to appeal it, and they said, no, you're not allowed to appeal it because the same legal advisor looked it over that handled the court case. And so then it went into the administrative court, which is the next step up. Well, paperwork was filed, quite lengthy because I did part of it. And the next thing was they said, okay, and we submitted the documents properly. We gave it to the other side. We filled out a certificate of service. We filed it in the court. And after 30 days, we said, okay, we want a court date because they're not responding. Well, the court turned around and wrote back and said, well, we're accepting paperwork from the other side at this point. Wait a minute, you're not allowed to do that. It has to come through me first and then the other side. So the court is now operating outside its legal authority. And that's the administrative court. So now what are you going to do?
Mm.
They just voided your court case, so it will never be public record. That's what they're trying to do.
Right. And then
And
when you point, so you can point that out to them, and that's it really, because they're acting wrongly.
Right, but let's say that court case was against you because you're a good target. I'll pick on you.
Thanks.
Let's say that was your council tax. Yeah, no problem.
Yeah.
And so you go to the regular magistrate court. You prove all the violations. They don't care because you're not allowed to put any sort of defense in. So then you appeal it because of all these violations, and they wouldn't listen to you. They deprived you due process of law. And now you go to the administrative court and you find out the administrative court's wrong. What are you going to do now? Because you need a legal judgment to recognize your rights.
Right.
So they're operating illegally. Yes, they have no legal authority now, but that doesn't stop the stupid council tax people from bothering you again.
Mm.
So then you're going to go through the same Mickey Mouse Clubhouse court all over again? No. Right? You had enough of this crap. And this is where people are going to have to stick together. And it's one of your presentations said, people have to come together as a community.
Yes. Yes. No, absolutely. Very much key.
Yeah.
Well, listen, this is we're about an hour and 20 into this, and I try to curtail them to about an hour. I don't want to put people off on for future ones, because I think some of the future ones that you've got lined up are quite juicy, if I can put it like that. The council tax and the DVLA, I think, will be fascinating, and of course anything that stops the ULEZ and the 15-minute city stuff, as you talked about, a silver bullet. So we'll definitely have to get you back if you're up for it.
I am.
And get this stuff out. So we've sort of broadened our introduction. We've talked about the maxims. We've shown that the importance of learning your own case and being doing your homework and getting the paperwork filed. Next up, we'll see how you can actually go to battle, as it were, and approach it.
Sounds good.
Yeah. Thank you so much, Stan. Really appreciate that. I hope that, ladies and gentlemen, you've been making notes and preparing yourself for the next batch of presentations as we take this battle to the courts and win, hopefully. A big thanks to Stan. I will be back with more of these videos and others in due course, but better end it here. So thank you very much to Stan, and talk to you all very soon.